Good morning. An important proposition of law that whether irretrievable breakdown of marriage be considered under Hindu Marriage Act for divorce under the caption of 13(1)(a) divorce on the ground of cruelty as well as desertion. See, the Supreme Court in AR 2023 4920 Dr. Nirmal Singh Panesar versus Paramjit Kaur Panesar alias Ajinder Kaur Panesar has validly held the dissolution of marriage on the ground of irretrievable breakdown of marriage. The problem is the judgment discussed about this ground. Initially they say the very beginning of the judgment, Justice Belayam Trivedi said, should the irretrievable breakdown of marriage necessarily result in dissolution of marriage in excess of power under section 142 of the Constitution, when such is not ground for divorce under the Hindu Marriage Act? This question was posed before the court. The ratios are very narrow. They say the husband and wife are 89 and 82 years and there was some problems. Therefore, wife claim was that she do not want to die as a divorced wife. Considering the sentiment of wife, exercise it is in favor of husband, marriage under marriage was irretrievable breakdown, would not be complete justice. Divorce was not granted. The term cruelty, word cruelty has to be construed and interpreted considering type of life of parties are concerned, their accustomed to, their economic and social condition, their culture and human values to which they attach importance. Each has to be decided on merit. This is the ratio. They have discussed about multi-number of the cases. They have says cruelty and desertion are legitimate grounds for seeking divorce of under section 13(1) of the Act. It is well accepted proposed the cruelty is a course or conduct of one party which adversely affect the other. Cruelty may be mental or physical, intentional or unintentional. This court summarized the principle of law on cruelty as under. Multi-number of cases were discussed about the cruelty and desertion, and finally, after deeply discussing, they have given issues, activities, professional. The respondent all throughout her life has maintained the secret relationships 1963 and has taken care of her 3 children all these years, despite the fact that the appellant husband had exhibited total hostility towards them. The respondent is still ready and willing to take care of her husband and does not wish to leave him alone at this stage of life. She also expressed her sentiment that she does not want to die with the stigma of being divorced. In contemporary society, it may not constitute to be stigma, but we all are concerned with the respondent's own sentiment. Under the circumstances, considering and respecting the sentiment of respondent by the court is of opinion that exercising discretion in favor of appellant under Article 142 by dissolving the marriage between the parties on the ground of that marriage has retrievably broken would not be doing complete justice to the parties, would rather be doing injustice to the respondent. In view of the matter, we are not inclined to accept submission of appellant to dissolve the marriage on the ground of irretrievable breakdown of marriage. Appeal was therefore dismissed. So appeal was directed against the High Court judgment LPA prepared by the appellant husband, whereby division bench of High Court, while dismissing the confirmed the judgment degree date passed by the single judge. which was preferred by respondent wife against the judgment and degree dated passed by the district, wherein lower court has given divorce and the single judge rejected it. Therefore, this the Honorable Supreme Court has, after discussing, you cannot take the judgment slightly for no ground for divorce, but it was a different style of argument. Consideration was totally different. But you can go through, after going through the entirety of the judgment, it will be helpful for you to work out your remedy on a strong case of cruelty and on different set of facts. Therefore, kindly take down. Best